Good evening. This is Mark Pennak, Maryland Show Issue. I'm the president of Maryland Show Issue, and I'm delighted to be able to join you tonight for this little chat. As you probably already know, on Facebook Live, there is a comment section on the left that people can submit comments, um, and I will try to answer them to the best I can. And fair warning, um, if I sound like a lawyer, it's because I am a lawyer and I have been for 45 years. So I really can't talk any other way than sound like a lawyer. But if you have any questions about what I've said that if I drop into legalese, please just drop me a note on the comment section and we'll try to respond. First, a word about Maryland Show Issue, of which I'm a president, and we have a webpage. Doesn't everyone now? It is at marylandshowissue.org. It's all one word, Maryland Show Issue. And it tells what we're about and what we do. And we post an incredible amount of information there about Maryland, about the state legislature, and about litigation. And basically, Maryland is an all-volunteer, nonpartisan organization dedicated to the preservation and advancement of gun owner rights in Maryland. You notice I didn't say gun rights. Guns don't have rights. People have rights. We educate the community about the right of self-protection, the safe handling of firearms, and the responsibility that goes with carrying handguns in public. That's our mission. But we have spent an awful lot of time in court lately. So we litigate a lot. And I spent 33 years at the Department of Justice as a litigator, mostly in the federal courts of appeals at the United States Supreme Court. And before that, in a big private law firm litigating for corporate 100 corporations. So litigation has been my life, all my adult life. So that's what I do best. But I spent an awful lot of time before the General Assembly of Maryland during the legislative session, which runs from January to April. And I will tell you that is always challenging. And what I would like to discuss tonight, some of the things that people can do to help preserve their rights before the General Assembly. So let's start off with the idea that, and the recognition that the General Assembly is a hostile forum to people who care about being their self-protection and their right of self-defense. And make no mistake, you do have a constitutional right of self-defense. The Supreme Court has recognized it multiple times, and this even state law recognizes it. And we'll get into some of the details about how that right can be protected and in litigation. But this state is one of the very few states in the country, only one of 8, does not allow the average citizen to carry for self-protection. A law-abiding citizen in 42 states, including the District of Columbia, of all places, have the right to have a carry permit. 13 states don't even require a permit, so that any law-abiding person has the right to carry with them. The rest of them have carry permits, and they are issued on a shall issue basis. And hence our name is Maryland Shall Issue. That is one of our objectives in Maryland, to have legislation passed, our court orders, if necessary, to have legislation that allows Maryland to join these 42 other states to issue carry permits on a shall issue basis. So let's just chat about what happens in the General Assembly. So it is a highly partisan environment. And the partisanship has gotten much worse over the last several years that I've been doing this. And I've been testifying in front of the General Assembly on bills since 2013. And it has gotten more and more hostile since. And this last legislative session was probably the most hostile. So on the House of Delegates side, we have a new contingent of representatives and delegates who feel strongly that guns should be eliminated if they possibly can. And they recognize that they can't get rid of all of them because of that pesky Supreme Court decision in D.C. versus Heller, but they will try to make it as difficult as possible. And this has stretched back for years within in the state of Maryland. Indeed, goes back over a century when Maryland, like many other states at the time, were trying to discourage in the post-Civil War era minorities from having access to firearms. So much of what we have here in current law is a legacy of that sort of legislation. So on the House of Delegates side, I testify, and I urge everyone to testify before members of several committees. And that's where the work of the legislature is done, in committees. So if you bypass the committee stage, you're basically missing the whole boat. So what we found to be the most effective way to go about doing this is to actually get to know your legislator. And it's easy to do. On the Maryland General Assembly site, there is a link that allows you to enter your address, and if you do, it will pop up with information on every one of your representatives, including contact information. That allows you the opportunity to get to know that legislator. And you shouldn't wait until the legislative session. You should get to know them now. If you have friendly legislators, it's important that you get to know them because they need to hear from you as well. If you have people who are hostile to the right of self-defense, they need to hear from you as well. You're a constituent. They won't say no. I mean, they may not be able to meet with the actual legislator, but a member of their staff will meet with you. And even if they just write it down, that there was a member of the constituency who came in and felt strongly enough to come in and speak to them, that will make an impact. In my shallow youth, I worked for a member of Congress on the House side, and the thing that mattered the most to that member of Congress was constituent input. Not that necessarily it was controlling, but it always mattered to hear what they had to say. And the most important constituent input are people who actually show up in a district office or during the legislative session in Annapolis just to talk to the legislator. And you can do that by setting up an appointment. And I urge everyone to do that. That allows you to have a time in which you can deliver your message. Failing that, then telephone calls are the most effective. And failing that, an email. But by all means, don't join in a group email because they just get piled in the corner. And email to someone who doesn't represent you is simply trashed. So the way to work this system is work through your actual representatives. And don't be shy about that. They do work for you. We always tell our members to be civil at all times because being not civil doesn't work in this environment, but to make sure that people understand what their notices are. And then the most important point is to show up during hearings. Every piece of legislation that is submitted by a member of the General Assembly before a certain deadline gets a hearing before a committee. And that's where they need to hear from you. And it can be enormously effective. For example, and I want to mention this because it was a vivid example. This last session, there was a bill that would have extended the existing ban on carrying weapons of any kind that exists now for public schools. They would have extended that to private schools, including religious schools. And a number of individuals from Baltimore County came in and said they were organized to protect their schools. These were Jewish schools. And they told such a convincing story how they protect their synagogue and the schools associated with their synagogue, that legislation died in its tracks and went nowhere. And that was in the House of Delegates, the place that's most hostile to gun rights. So it can make an enormous difference. In 2013, this General Assembly passed the Gun Safety Act of 2013, so-called. And on it, they were going to ban every conceivable type of scary-looking firearm they like to call assault weapons, which are really no more than semi-automatic rifles of medium to low power. And but for the testimony of one 15-year-old girl who was a nationally ranked competitor with one of these rifles, and she was using it to get a scholarship to college. And as a result of that testimony, the bill was radically altered to exempt large numbers of firearms that would have otherwise been banned. That one person made a difference. And if you're not registered to vote, oh my Lord, you have to register to vote. Because the first thing someone will do as on the legislator's office is check, one, are you a member of their district? And two, are you a registered voter? Because if you don't vote, your voice is not heard. And don't think for a moment your vote doesn't count. Votes elections are decided all the time on a slimmest of margins. I mean, in 2018, a Senate seat in the United States Senate was decided by 568 votes. That's a Senate seat. So it makes a difference. So, and you vote in the primaries, because that, in so many of the areas of Maryland, is where it makes a difference, because primaries in this state, where it has a 2-to-1 Democratic Republican registration margin, many of the Democratic candidates are chosen in the primaries, and they will prevail in the general. So that is just enormously important. So I wanted to also speak to you about where we are in the Second Amendment and nationwide and Maryland itself. The Supreme Court punted this last year on a case that we hoped would make a lot of difference on what the right standard of review for Second Amendment cases. Currently, the federal courts of appeals are basically saying, doing a balancing test. If the gun rights survive, if the legislation survives this balancing test, it's deemed to be constitutional. It's not the test that the Supreme Court has used, but it is a test that these lower courts have adopted. And unsurprisingly, every single case in which this balancing test is applied, the gun rights lose. So we were hoping this case called New York City versus New York State Rifle and Pistol Association would, in fact, help set a new test, the test actually used in the Heller decision. But unfortunately, New York and New York City abandoned their statute that was being challenged, and the Supreme Court declared the case moot. And this last spring, only a month or so ago, the Supreme Court declined to hear 10 other cases, Second Amendment cases, that were scheduled to have been pending, in some cases, for more than a year before the court. So right now there's nothing pending in the Supreme Court. There are a number of cases pending in the lower courts which still might make their way up to the Supreme Court, including a case called Young versus Hawaii, which the Ninth Circuit has in bank right now, and that will be argued in September. So the important point I wanted to bring apart is that this game is a long game, and we are not done by any means, but we're not on the cusp of any new revolutionary decision by the Supreme Court. It will take years more of litigation before that happens. And meanwhile, Maryland Show Issue will continue to litigate. We recently lost by a narrow 2-1 decision on the state legislature's desire to ban personal property, and we are now have filed that was a so-called bump stocks litigation. So they banned the possession of existing lawful property and refused to pay just compensation for it. And the Fourth Circuit, United States Court of Appeals, sustained that on a 2-1 decision. And the dissent made it very clear that you just cannot ban personal property that was lawfully acquired. So we are continuing to litigate that. We have pending also before the Fourth Circuit, the handgun qualification license. And I want to talk briefly about that. Handgun qualification license was enacted in 2013 to mandate that a person obtain a handgun qualification license in order to purchase a handgun or otherwise acquire a handgun. and it requires 4 hours of training by a state certified instructor. It requires fingerprinting by an electronic scan. It requires a $50 application fee and an online submission of the application. And part of that training requires that the person go to a range and fire 1 live round of ammunition. Now, as an instructor, I can tell you that firing 1 live round of anything doesn't amount to any kind of instruction that's worth having. But it was enacted by the state police with the very purpose of discouraging people from getting the handgun qualification license. There are, for example, no ranges in the city of Baltimore that are accessible to the public. There's only 1 range in the county of Montgomery County. There are none in Prince George's County. Very few ranges exist in Maryland that are otherwise publicly accessible. So you not only have to get this qualified instructor to teach the course, he has to have access to a range to take, and you have to travel out to the range. No instructor that I know of will provide transportation to the range. So you have to travel, and so you can fire 1 live round. It makes no sense unless you understand that this very effectively discourages people from applying. We had information in this litigation that 40,000 people started applications only to give up in the process of doing this. And you have to do it on a computer as well, so you better have a nice computer with a solid internet connection, because there's no other way to ask for this handgun qualification license. Now, we're litigating that in the Fourth Circuit. We recently had an oral argument on a standing argument because the district court said none of us, including Maryland Show Issue, had standing to challenge these requirements. But we had a very successful argument, and we were hoping for a favorable opinion in that case soon. So in which case we'll go back to district court and we'll continue to litigate. But there's where we stand on the national level. On the local level, if you go to the Maryland Show Issue page website and you click on the legal menu right at the top, and you have it, there's a drop down for litigation tracker. And on that litigation tracker you see, let's go to the Maryland legislation. You click on the legislation tab, and you will drop down and see all the bills that were proposed last year, and some of which passed, only to be vetoed by the governor. And they were arduous, to say the least. And that is an extremely useful site for people to go to, because we keep track of every gun-related or crime-related bill on that legislation tracker. We give you a copy of our testimony. We give you a link to the actual bill itself. We tell you what our position is. We have a copy of links to press reports and the like. We update it on a continual basis so we can tell you where it is. And we information about the hearings, when they are, what in front of what committee they are, and how to show up, basically, and be heard on these bills. And just if you go through that legislation table, you can imagine how some of these bills ever got to there. And what did pass last year, but Governor Hogan vetoed, was a bill that requires you to get a background check for a private sale of a long gun, an ordinary shotgun. Now, we presented very powerful evidence, and it was really undisputed from FBI statistics and the like, that you're more likely to die from being beaten to death, much more likely to die from being knifed to death, and even hands and feet are more likely to kill you than a long gun. And so the question we put to the proponents was, why aren't you regulating the private sale of knives and baseball bats? And of course, that was not well received. So they passed this bill in one form in the House, and then in the Senate, they were also going to try to require a background check for a loan. So if you loaned your shotgun to your neighbor, or your goose gun, so he could go hunting the next day, you would both go to jail for 3 years. If he brought it back, even if you did do that, if he brought it back to you, you would have to go back to the dealer and get another background check so he could return it to you. We managed to persuade the Senate that the NICS check that this bill required, that's the National Instant Background Check that the FBI runs out of West Virginia, doesn't allow for dealers to access it for loans. And that part was actually removed from the bill. You can see how effective that was. That took lots of time and legal research and a written submission to convince the Senate that that part of the bill was simply illegal. And it illustrates a point that many people don't understand, is that most of our legislators know very little about firearms. Extraordinarily little. So our function is both to try to educate them, but also try to make sure that they have the ability to see issues that they don't otherwise understand. And sometimes they listen. And we understand, of course, we are nonpartisan by charter, so we don't give campaign donations or recommendations, but we understand where our friends are in the General Assembly. And I will say, I give a shout out to, in particular, to the Republican members of the Senate Judicial Proceedings Committee, Senator Huff, Senator Reedy, Senator Casserly, who all have been extremely knowledgeable and extremely helpful in talking sense to their counterparts on the committee. So they have been outstanding, and we wish to express our appreciation to them. And I will even express our appreciation to Senator Smith, who's the chair, for his willingness to listen. So often, we're not even listened to. So it's refreshing and encouraging to find a chair that will actually listen. Unfortunately, we don't get that much listening to in the House, and which is where even more partisan than it has been over the years. So, but we, even there, Republican colleagues have made an impact by asking hard questions and making people defend indefensible positions. So, and I'll give you an example. One of the long guns that's not banned in Maryland, the so-called assault weapon, is a heavy barrel gun. They roughly run about $2,000 a piece, and they're used exclusively in competitions where the heavy barrel is very important to accuracy. There was a bill to ban it this last year, and indeed ban even more guns than banned in the past. So we owe a big debt to the members of the Republican delegation and the House who helped us persuade the Speaker not to press that bill, so it was voluntarily withdrawn. So it is an important part of the Republican mission here on these gun bills to speak sense, even though they're in a small minority, if you will, a veto-proof minority. So they still have an impact, and so they deserve your support, and they certainly have our support. So let's talk about a few of the things that people want to know on the questions, and I have a few here that are already being sent to me and are also posted. And I've talked about one thing was the most effective techniques to getting favorable Maryland Second Amendment legislation passed. Well, you're not going to get favorable Second Amendment legislation passed in the General Assembly. It just isn't going to happen. Even if it passed one chamber, it doesn't pass the other. And a perfect example is this. There is a bill that's passed every year for the last 3 years in the Senate. And that is for people who wanted to get a carry permit right now, they have to get 16 hours of training before they can even apply. In most states which require training, people are allowed to apply, and this includes the District of Columbia. And then if their application is otherwise in order, then they can then get the training after being told that they will get the permit if they have the training. But not Maryland. Maryland makes you get the training first before you can even apply. So this training is expensive, $500 to $600 for 16 hours in a class, and takes 2 days. But that's 2 days of wasted and $600 wasted if you apply and are denied. And that is a common sense piece of legislation that other states have followed, that the Senate saw the sense in, and yet got absolutely nowhere in the House of Delegates. So getting favorable Second Amendment legislation passed is virtually impossible in Maryland. it is possible to defeat unfavorable legislation. We've talked about that. So uh, one question here is, what are the major differences in requirements for new gun orders between handguns and long guns? And it's enormous amount of differences. Handguns in Maryland are called regulated firearms. And regulated firearms are basically all handguns and assault weapons. And assault weapons were banned back in 2013 for the purchase of them, but existing owners still were permitted to keep their existing guns. But they're still deemed to be regulated firearms. So for a handgun, we were talking about, you had to get a handgun qualification license. Now, the state legislature 2 years ago wanted to make this also applicable to long guns, called a long gun qualification license. But when they learned that it would cost $12 million for the state police to man it, they dropped that requirement. So, but for a handgun, you still have to get a handgun qualification license. You have to jump through all the hoops, which you already mentioned, to actually buy a handgun. And that requires actually getting the handgun qualification license. The state police have 30 days once you've completed your application. You have to get your instructor, who has to be a registered qualified instructor by the state police. He has to verify your application. You have to submit this online by attaching your certification from the instructor and your live scan receipt that shows that you've had your fingerprints taken. And then you have to wait. And you can wait up to 30 days or more. They have 30 days to grant you that, but we've had lots of cases where it's gone more than 30 days. And then you get the little card in the mail that is your handgun qualification license. It's good for 10 years, after which you have to renew it. And with that handgun qualification license, you can march over to the federal firearms licensee and say, I would like to have that one, and point to a handgun. And he'll be happy to sell it to you, except that you have to wait another 7 days and fill out another form. This one's called a 77R. That goes to the Maryland State Police. And you have to fill out a federal form. That's called Form 4473. That goes to the federal NICS system that the FBI runs. And you have to wait 7 days while they do another background check, even though you just had a background check for the handgun qualification license. They have run another one. And at the end of the 7 days, you are allowed, if the state police say so, to pick up your firearm. Only then. And by the way, you can only buy one handgun a month, unless you're a designated collector, and that's a different story. So difficult to buy a handgun in Maryland. It takes time, it takes money, and it takes a lot of patience. And that's all by design, because Maryland's official policy for some time and unofficial policy has been to discourage people from the private ownership of guns, handguns in particular. So that's difficult. Now for a long gun, ordinary shotgun, like for pump action, you can just go to the dealer and put down your money, and the dealer will sell it to you after doing what's called the NICS check. And they can do that online. It takes less than a minute sometimes, a little more than some other times. And within those 3 or 4 minutes, you will have a NICS check. The FBI will verify that you're not a prohibited person, and you can walk out the door with your long gun. That used to be what the rule was for handguns in Maryland, but that's been changed for a long time. So you can still buy a long gun, except not so much right now, because most of the long guns that you can use just a NICS check for are being sold like hotcakes out of dealers because of the current civil unrest. I've gotten many calls, and I know lots of instructors who have gotten many calls asking for people, how do I get the handgun qualification license? And we tell them that they have to do all what I've just described and wait 30 days. They become incredulous. They had no idea. And these are people who, from all walks of life, all races, all creeds, who all desire one thing in particular, the ability to defend themselves and their families, which is, of course, their constitutional civil right. And yet they are distressed to find out that they go to the gun store, the long guns are sold out, and they can't buy a handgun. So that's where we stand on that. So another question I see, if you have existing guns, do you need to get registration? And the answer is no. Registration when you buy a handgun takes place at the time of the purchase. That 77R form that you're required to fill out, well, and that's all online now as well, that serves as a registration of that handgun and you as an owner. And you may not sell that handgun to anybody else unless they complete the same 77R process. You can do that either at a dealer or a state police barracks. But that gun is registered to you and to you alone, and that is information that the state police will keep forever. For long guns, there is no registration requirement whatsoever. The dealers keep a copy of their Forms 4473 at the dealer's location. It is not shipped off to the FBI. They're prohibited by law from keeping these forms for past the time for a next check, so that they don't have a nationwide database of long guns. But the state has a database of everyone who owns a handgun. New residents that come within the state for the first time who own a handgun or a regulated firearm, well, they have to register that under Section 5-143 of the Public Safety Article, and they have 90 days to do it. And if they fail, they could go to jail for 5 years. Think about that for a minute. I forgot to register, or I didn't even know I had to register, and I could go to jail for 5 years. That's the kind of draconian legislation that your General Assembly passes. But if they had a so-called assault weapon that they bought after October 1 of 2013, they can't bring it into the state, even though it was perfectly legal in the state that they had it, even though it was registered, if there was a registration requirement, in the state from which they brought it. They have to leave that at home. They're not allowed to transport it into the state at all. That has major implications for people who are trying to run competitions within the state of Maryland using these firearms. They simply can't be transported into the state at all if they were purchased after October 1, 2013. And the state police will enforce that. So it is a big difference, and there's lots and lots of traps. But it's important to also talk about the restrictions that are placed on existing owners. It's extremely strict. So you may possess your handgun in the home, and you may possess it on the property which is your residence. If you own 1,000 acres, you can carry it anywhere in 1,000 acres. But you may not carry it off the property unless it is to one of the allowed locations. For example, you could carry it unloaded in an enclosed case or holster to a range. You can carry it to the gunsmith. You can carry it between residences if you have multiple houses in Maryland, unload it in an enclosed case or holster. And you can carry it to your business if you're a business owner, and you can carry it back home. But that only applies to the transport. So if you stop, and I've had this conversation with a number of people, and they don't understand this, so it's a potential risk. It's a trap. So if you go to the range and you shoot your handgun, perfectly legal, and you're on your way home and you decide to stop at the mall for a little shopping, well, you've just interrupted your trip. You're no longer transporting the handgun from the range to your home. You're transporting the handgun from the range to the shopping mall, and that will land you in jail for 3 years. All because you made an unauthorized stop. Now, there's very little case law on this, and so it's open to completely arbitrary enforcement. And the arbitrary enforcement is if the officer decides he doesn't particularly like you for whatever reason, then you can imagine how he's going to enforce this. It's open to abuse, and it has been abused. I'll give you another example. Pennsylvania is a shell issue state. Residents can get a carry permit from them if they're otherwise law-abiding citizens. Virginia is a shell issue state. It allowed the open carry of firearms, including handguns. But there's a narrow strip of land up near Hancock, Maryland, that separates Maryland, Virginia from Pennsylvania. And if you get stopped going from Pennsylvania, even though you may have a carry permit from Pennsylvania, if you get stopped in Maryland, you go to jail for 3 years. Even though you have a carry permit, even though you otherwise didn't do anything wrong. Because Maryland recognizes no state's carry permits. There is no reciprocity. There is no recognition. So even though you may have carry permits from multiple states, even though you may be a law-abiding resident in these other states, it simply will not protect you in Maryland. People don't understand that either. So it's something that's a trap. So I just got a call, for give you an example, of a person who, a second lieutenant, who was going to attend school at Johns Hopkins, and he says, what do I have to do to bring my handgun in the state? And I laid all these laws out to him, and he was flabbergasted. So wait a minute, if I stop, I could be arrested? And I said, well, yes, you could. And what do I have to do? And I told him, well, he has to keep it within his house. And he said, well, where can I shoot it? At a range, but you won't find one in Baltimore where Johns Hopkins is, because they don't have any. So you have to drive. But don't stop on your way to the range or stop on the way back, because that's not allowed either. You stopping for gas? Well, it's up to the discretion of the officer and what he thinks at the time, doesn't it? And the Baltimore City Police Department is very hostile to guns. So even people with carry permits stay out of Baltimore simply because the prospect of getting arrested is very high, even with a permit. And that's not just a hypothetical. We've had a number of instances where people with carry permits are in fact arrested because they arrest first and ask questions later. So it's a very fraught legal environment for gun owners in Maryland. And there's a syndrome, what we call this, is a battered gun owner syndrome, which you find among Maryland gun owners, because they're so afraid of being arrested that they self-censor themselves so that as to avoid getting passing, somehow tripping over a line that they didn't know existed. So let's active lawsuits regarding concealed carry. Well, we did have Maryland Show Issue actually represented a member all the way up into the Court of Special Appeals, which is in Maryland is the Intermediate Court of Appeals. And the Maryland Court of Appeals said, well, you didn't preserve this in argument before at the time, the Handgun Permit Review Board. So you've waived the argument we don't have to consider, and guess what? We're not going to consider it because it's too hard for us, and maybe the Supreme Court will provide guidance. And so they punted it. Now, if you weren't a member of the Maryland Bar, and I am a member of the Maryland Bar and the DC Bar, you would not know that you would have to present your constitutional arguments before a 5-member lay panel of people who don't understand the law. They're laymen, they're not lawyers. And yet the Court of Appeals said, well, you should have, and we're going to enforce it and not consider your arguments. Therefore, you've been waived. Even though you went to court and you made all the arguments, even though you make all the arguments to us now. And how would anyone know that? Well, you wouldn't, because it's not publicized. That requirement is simply a matter of case law. And the only people who read case law are lawyers. And most lawyers would not know enough to tell you that there is this exhaustion requirement in Maryland law for making sure you make all your arguments for the administrative agency. So the Handgun Permit Review Board is now defunct because they were overturning the state police too often, so the Maryland General Assembly abolished them. Just like that. So they didn't like the results, so they got rid of it. Instead of, so now you make an application for a carry permit to the Maryland State Police, and you still have to present what they call a good and substantial reason. And if you are denied, your right of appeal now goes to the Office of Administrative Hearings, which is in Hunt Valley, north of Baltimore. And there you must make all your arguments because they are going to be waived. And so it's a quasi-formal hearing for which it has rules of procedure and discovery. You really need a lawyer. And if you have a proceeding there, appeal, it's going to cost you around $2,000 to $3,000 for the lawyer to represent you. that serves as a huge block to people. Now, it is possible to get a carry permit in Maryland. I have one. And, for example, all business owners, well, we managed to persuade the state police that business owners shouldn't have restricted permits. And before, they were issuing permits to business owners, which were restricted to while you were conducting business. And we pointed out to them that no one knows on the side of the road, how are you going to prove to the state officer or to the county police officer that you were conducting business? And the likely result is an arrest. And we had multiple instances of that happening. So they saw the light into that one and they abolished the restriction. But the reality is, if you have a restricted permit, like an employee would have a restricted permit while serving as an employee, if you are outside your permit restrictions, well, it's the same thing as having no permit at all. 3 years in jail. So it's, again, fraud. People with top secret security clearances get unrestricted permits. It's a new standard operating procedure that the state police issued last August that most people don't know about. And by the way, it's really hard to find on the Maryland State Police website. It's there, but it's buried. And they list all the reasons that they will give a Maryland state carry permit. And one of them is a person who has a top secret clearance. You still got to get the training. You still have to 16 hours of training. You still have to do all the rest of the fingerprinting and the other requirements, but they will give you a permit. So any of my listeners out there who have a top secret clearance and want to carry a permit, they should join Maryland Show Issue, because we help our members through this process. It's a perk of membership, by the way. And we will help you, guide you through this process. We almost all of us have gone through this process, so we're familiar with it. I am on a first name basis with the captain of the licensing division of the Maryland State Police. We're trying to work out problems as they arise. And we can help you through that process, but we can't guarantee you anything. So top secret clearances people with holding those clearances can get permits. People who are special people, judges, prosecutors, security guards can get permits because they're called an assumed risk category. Now, the state police will deny it, but the reality of this is that state police are happily to give assumed risk permits to members of the General Assembly, apparently on the theory that politicians are unpopular. But they won't advertise that, which is a shame, because the state police treat a favorite class there. But the ordinary citizen, unless he has documented threats of attacks or threats, in other words, if you were threatened by somebody with a knife, you have to report it to the police and have that police report in hand. And they may require you to have more than one such report or attacks. Of course, arguably, it might be a little too late then. So they have to be able to show that. And by the way, your permit is good on the initial term for only 2 years, at which time you got to start all over and do everything over again except for the fingerprinting, because they keep your fingerprinting forever. So if 5 years from now or 10 years or 20 years from now you still have a permit and you're in the state of Alaska and you commit a crime or arguably are arrested for something and your fingerprints are taken, that information is transmitted to the state police within 72 hours on an FBI program called a Wrap Back, and the state police will lift your permit that fast. So the idea that you need to continually check on people for 2 years or every 3 years on renewals is completely belied by the reality that folks have got a system in place that the state police can immediately revoke a permit whenever there's a reason to. So active lawsuits, one of the Wayland case that was pending, and we had several active lawsuits. There were 5 active lawsuits pending in the Supreme Court at the time that this last term as of May. The certiorari was denied in all 5, which means those cases are all dead. There is an active carry lawsuit now pending in the Ninth Circuit in bank. That means before the entire Ninth Circuit, or a panel of the entire Ninth Circuit, 11 judges. And that case is called Young versus Hawaii. That's the one that's pending now. That's furthest along. And that will probably be presented to the Supreme Court after the Ninth Circuit issues its decision in that case. That case won't be argued until September. The Ninth Circuit typically takes like a year or sometimes more to issue a reported decision. And so that's a ways off. Maryland Show Issue is interested in litigating this again in the state courts, and so that Mr. Whalen may well be going back again after he has made sure to exhaust all his remedies before the Handgun Permit Review Board and the Circuit Court, and we'll try again, because the state courts are not bound by the federal court decisions. They're bound by the Supreme Court on questions of federal constitutional law. But a state court can decide to disagree with a Court of Appeals decision. Maryland is in the Fourth Circuit Court of Appeals, and that includes Virginia and West Virginia and North Carolina and South Carolina. And so the Fourth Circuit decisions are binding law in federal courts, but they're not binding in state courts. So we'll proceed in state court. Sooner or later, this issue will come back up before the Supreme Court, and hopefully the Supreme Court will decide to take it. Thus far, they have avoided taking Second Amendment cases since they issued a decision called McDonnell in 2010, in which they applied the Heller decision to the states. It's called an incorporation under the Due Process Clause, because technically the Second Amendment applies only to the federal government unless it's incorporated. And most of the federal constitutional rights are incorporated against the states under the Due Process Clause of the 14th Amendment. I'm dropping into lawyer expertise here, so forgive me. So, how many gun violations are actually prosecuted in Baltimore? And that's the great irony. Baltimore is one of the most crime-ridden places in the country. It is the leader in murders per capita in the country. They have more murders in Baltimore with a population of 600,000 than they do in the Philadelphia, which is three times its population. So the irony is that gun laws are not being enforced as a matter of prosecutorial enforcement. They typically are arrested, they get plea bargained out, or the charges are dropped, and the perpetrator walks away. That's not true in other states. I mean, in other jurisdictions in Maryland, where gun charges are in fact prosecuted. But in Baltimore City, the state's attorney has decided that she's not going to prosecute many of these charges. It's not just gun charges. I mean, some murder charges have been dropped. So it's breathtaking, because Baltimore has become virtually lawless. I make it a point not to go into Baltimore. So I'm going to move the mic away, because I'm told I'm speaking into the mic too much. So that's sorry about that. We have other questions here that I've gotten in email that I wanted to address. So we have a question here from Brenda, and she talks about the right to home protection. And her question is, an intruder bashes down my front door. I grab my gun. I don't have a carry permit. I do not qualify for one. What should I do? Is there a castle doctrine in Maryland? And the short answer is, yes, there is a castle doctrine in Maryland. Maryland is a duty to retreat state, which means outside of your home, before you're allowed to use deadly force of any type, not just a firearm, you must make an attempt to retreat, to avoid the use of the force, if the retreat is safely available to you and you can pull it off. Obviously, if you're in a corner, you may not have a duty to retreat, because there is no retreat, and the courts recognize that. But in the home, there is no duty to retreat. So that's the castle doctrine, and dates back to the 1600s in England. and has been incorporated in the law of virtually every state in the country, and including Maryland. And all this is in case law, by the way. It's not in a statute. You won't find it in the law books. You have to dig in through the case decisions. But the other elements of self-defense still apply. And I have them here. Let me just reach over. And this is from a case called Faulkner. So it's important to parse these out very carefully. You have a right of self-defense, and it's a complete defense to a charge of murder or assault or any other charge if you meet every one of these elements. And the first one, and probably the most important, is the accused must have had a reasonable grounds to believe himself in apparent, imminent, or immediate danger of death or serious bodily harm from his assailant or potential assailant. Now this is multiple facets here. So it's reasonable grounds. In other words, would the hypothetical non-existent person who's the reasonable man in the law actually think, yeah, it's imminent. It's about to happen. It has to be imminent. In other words, it can't be a long ways off from you. It can't be attenuated by barriers where you cannot, they can't get to you. And then it has to be death or serious bodily harm. That's sort of the fears. It can't be just a punch in the nose. For some people, that might be a serious bodily harm. For others, it may not. But it depends. Those are questions for the jury, the fact finder. So that's the key situation. So if you're in your home, that doesn't mean it's a free fire zone. It means that you have to satisfy that element from someone who's an intruder. If the intruder is the 10-year-old little boy from next door who's looking for a cookie, you're not in imminent danger for that 10-year-old. So you can't shoot him. I mean, it's an extreme example, but it illustrates the point. So in the next element, you must in fact have believed yourself to be in this danger. In other words, even if a reasonable person might have thought that you were in fact in danger, if you knew that the person really didn't mean you any harm, then you are not entitled to this defense. Because whatever, you may know something special about the person. You may know that was a prank, just goofing around. The next element is the person claiming the right of self-defense must not have been the aggressor or provoked. In other words, if you're in an argument and you flip somebody off, you're part of the aggressor. Or if you agree to mutual combat, you're the aggressor and so does that other person. Neither one of you have the right of self-defense at that point. You know, there's other doctrine that allows you to break off the encounter, communicate that you don't want to fight anymore, and then the right resurrects itself. But if you are an aggressor or a provoker, you lose it. And the last is that the force used must not have been excessive. You know, okay, that's a tough one, right? So if the guy's coming through the door and you're a 5'3", I don't know how big Brenda is, but let's push 5'3", 120 pounds, and this is a linebacker, the size of a linebacker. Yeah, you probably have very strong fears that he's going to do harm to you. He's breaking through your door. Okay, that's imminent. Nobody breaks through your door to say hello, so they're undoubtedly intending to harm you. And you shoot him, as you probably could, 5 times, and he's on the floor, and you keep shooting him. Okay, if you keep shooting him, that's excessive force. And you've lost the defense. Now, you must, as the person claiming this defense, actually produce some evidence of each one of these elements. And that can be your own testimony. At which time the burden shifts over to the state of Maryland, the prosecutor, to show that at least one of those elements is not supported by evidence. In other words, to convince the trier of fact that the danger wasn't imminent, or that you or a reasonable person would not believe that they were in danger. And if one of those elements fail, you've lost the defense. Now, in a civil case, let's say that you survive the criminal case and you're acquitted for shooting the person that comes and breaks down Brenda's door. The family of the perpetrator that broke down your door can sue you civilly, at which the burdens now shift again because it's a civil case. And they're not putting you in jail, they just want your money. You have the same elements you have to satisfy, but instead of having the prosecutor prove beyond a reasonable doubt that at least one of those elements is not present, you have to prove by preponderance of the evidence that all of them are available. Otherwise, you lose. So the Faulkner case, there's a civil counterpart to that that illustrates that very point. So it's something that is fraught with peril. So try not to shoot someone. It's a last resort. And Brenda and guy coming through the door may not have a choice. And if you don't have a choice, you don't have a choice. But when I teach a course, I try to teach people to be situationally aware so they can avoid the situations entirely. So they never have to resort to lethal force. And understand, too, that in Maryland, pointing a gun at somebody or merely brandishing it. In other words, if you have it on your hip and you pull your coat away and you show it to the other guy, that's first-degree assault. That's a felony. 20 years. So there are rules associated with carrying a gun that are legally perilous. So if you mess up, there's no do-over. So let's see, I have any other questions here? So I think I answered Brenda's question. So one of the questions he had was, so we have the Castle Doctrine in Maryland. And by the way, the Castle Doctrine also applies to defense of anybody else in your home. And anyone in your home can defend your home. It doesn't have to be you. It doesn't have to be the owner. But it applies to the home and the immediate area around the home, curtilage of the area. And there's a related doctrine called defensive habitation, which is allowed to defend the home. There's a metaphysical distinction in the minds of some between defending the home in order to prevent assault on an individual and defending the home as a structure. The elements are the same, except that you don't have to prove that you were basically in peril for yourself. You're in peril for your structure. But if you're in the structure, you're in peril. So that it also merges into the same inquiry. So, but you can defend your home under Maryland law, but understand that satisfying the elements is something that the jury's going to have to consider. And I will tell you that juries make mistakes all the time. So because the right is available doesn't mean you're going to win. So I hope that answered Brenda's question. So we've answered one question is what avenues available to a Maryland citizen wishing to appeal the decision of the Maryland State Police on a request for wearing carry permit. We just talked about that. You basically, if you're denied your application, you can go to the Office of Administrative Hearings. From Office of Administrative Hearings, where you have to preserve all your arguments, you go from there to the local trial court, which in Maryland is called the Circuit Court. And from there, you go to the Court of Special Appeals, and from there to the Maryland's highest court, the Maryland Court of Appeals. And the related question is what progress is there on national reciprocity for state-issued concealed carry permits? In other words, if a person who has a concealed carry permit who's resident in Virginia, that permit's recognized everywhere. And the answer is that's dead. That's not going anywhere anytime soon. There was some movement back when the first couple of years of the Trump presidency, but that died and has not resurrected. And the question is the infighting at the highest levels of the NRA, what has it done to the effectiveness of the organization? The NRA is, and I'm a member, and a valued member. They have helped us a lot within litigation within Maryland, and I very much appreciate that. Uh, they are under attack, um, and particularly by the state of New York and this governor in New York. They have done everything they can to basically demolish the organization and limit its funds. The amount of attorney's fees the NRA is having to pay every year is enormous. So it certainly is under attack, and those stresses have led to a lot of infighting within the NRA. I'm not privy to any of it. Um, I will say that if we need the NRA very much because they are the only nationwide organization that can take the fight up to Congress that I know of that is really effective. There are other organizations of which I'm also a member, like the Second Amendment Foundation, that's very effective in the courts. Uh, they don't have quite the carry weight in the general assembly or in Congress that the NRA does. So it has certainly had an impact on them, and I hope they work their way through it. But I don't have a dog in that fate, except I wish the NRA well, and I hope it survives intact, both against New York and against all other comers who are targeting the NRA. And it's interesting, they have become the bad boogeyman to people who are out to seize your guns. And yes, they are out to seize your guns. Don't make no mistake about it. They draw fire like nobody else I know, and sometimes you can actually use that against you. My friend over here in the NRA, and they're sitting there piling up on him, and they leave me alone as a state level organization, and that allows me to say what I want, but they take a hit every time because for some reason they view the NRA as a devil incarnate, when in fact they're just defending the civil rights of ordinary law-abiding citizens. You know, I'm an NRA instructor. I teach courses for the NRA. They are an outstanding organization, and their courses are outstanding. So I would encourage everyone to actually take one of those courses, including carry courses and including self-protection in the home, self-protection outside the home. We will teach you how to protect yourself in the home and how to protect yourself out, including how to draw so you don't shoot yourself or the person next to you, and we'll burn through a lot of ammunition. So, for example, the carry outside the home, which I teach, you'll burn through about 300 rounds in that course, and that takes 2 solid days. And by the time of that course, you'll be pretty up to speed, as long as you practice. So, another question is how I get a concealed carry permit. I think we've already covered that. This is a complicated question that another self-defense in the business. And yes, Castle Doctrine doesn't apply to the business, but if you have an intruder in your business, then all the elements of self-defense that we've already talked about fully apply there as well. Remember, in Maryland, you don't need a carry permit to have a gun in your business if you own the business or if you're a supervisory employee who the owner of the business has allowed to carry, has asked you to be armed. For example, if you go into a federal firearms licensee, almost every single employee in that federal firearms licensee will have a pistol strapped to their waist. And that is there to defend the business. And they don't go outside a building with that on their waist, but they can certainly carry it and defend themselves and their customers inside the federal firearms licensee. So, and again, the complicated question here is, what if you have a door in front of you? Well, that has to do with imminence. If they have a gun, can they shoot through the window? Are you permitted to defend your customers? And the answer to that is yes. And Maryland recognizes the right to defense of others. So even though you may be safe behind your plexiglass shield and your steel door, your customers may be out there getting robbed and threatened and perhaps even shot. And would you have the right to defend them? The answer is yes. And there's a case of that called Lee. And I have it here somewhere. They're basically the same elements. And that is where it's reasonable for you to believe that the person is in imminent danger of severe bodily injury or loss of their life. and whether or not you sincerely believe that was in fact something that you held, and that you didn't use excessive force, and that you weren't the provoker. Now, doesn't mean you have to be right, by the way. Now, I tell my students when they ask about defending others, I say, well, what if it's an undercover cop who's making an arrest, and you don't know that he's a cop, and you intervene and you stop the arrest, and maybe shoot the officer? So do you want to take that risk? And most people pause about that and think about it for a minute and say, well, no. So think about who ahead of time you're willing to defend and why. And think about the fact that if you successfully defend that person and you actually shoot somebody, the odds of being prosecuted are very high. Perhaps you'll win, but you'll certainly go spend hundreds of thousands of dollars in in legal fees. My members of the bar do not work for nothing. So are you willing to take that risk to save someone else? Now, the answer would be, of course, yes, for members of your family. It might be, of course, yes, for close friends who you already know. But a complete stranger? One of the scenarios that people think about, well, what if you see someone being assaulted on the side of the road or in the street somewhere? Well, do you know anything about that situation that you wanted to take all those risks for a complete stranger? You may want to simply call 911. Set up your camera. Take a movie of it. But pulling your gun, and if you pull it, it's the same thing. You can't pull it unless it would be legal to use it. Doesn't mean you have to use it when you pull it, but it means that you've just committed first-degree assault if you didn't have a good reason to do so. So that's where it gets very tricky. So yes, you have the right to defend yourself and the customers, and the same all your customers in imminent harm. Are you in imminent harm? I mean, could they shoot through your plexiglass? Well, yeah, with the right ammunition, bullets will go through plexiglass. So it is a matter of what you do then. Now, if you are in imminent harm, it means that your life is at risk. You don't shoot to wound, you shoot to stop the threat. You don't shoot to kill either. But the most effective way to stop the threat is shots in center mass, chest. So every student and every law enforcement officer is taught, do not shoot the wound, because it is precisely the wrong thing to do. One, you're not stopping the threat, and two, it will illustrate that you didn't believe the threat was imminent because you had time to actually shoot the wound instead of stopping the threat. It actually undermines substantially your right of self-defense. So is it effective? Do you have a right of self-defense against the knife? Well, of course you do, because a knife is a deadly weapon. But if the person wielding the knife is 60 feet away, how imminent is that? Well, not very. There's a case on that in Maryland where the person was 34, 50 feet or so, and the court held that was not imminent. There is a process that we teach in class called the Tueller drill, after Dennis Tueller, who was a police detective. And he determined after research that people within 21 feet can reach you with a blunt object or a knife, an edged weapon, before you are able to draw and engage. So if you've actually run the Tueller drill, you will find that it varies between 18 and 25 feet, but depending on the person and the skill in which they can draw. So if you're aware of that Tueller drill and someone's within that distance with a knife, then you're aware that you're at great risk. If they're 50 feet away, you know that the risk is not as great. So it's something that you can teach in one of these classes, the NRA classes, and any concealed carry class will teach that as well. So that's important for you to understand in terms of the right to carry. It's an awesome carry. And some people need a personality transplant in order to carry, because you really do have to learn that you don't get to say anything. You have to walk away. You can't engage, because if you do engage, if you do provoke, or you have mutual insults flying back and forth, well, then you've lost your self-defense rights because you could have walked away. And so if you can't walk away, you should carry. So, and this has to do with the question is protesters banging on my car. Okay, you can imagine 1,000 different scenarios, and you should if you're going to carry. One, you shouldn't have a gun in your car under Maryland law unless you have a carry permit. So we're talking about a situation where you already have a carry permit. If you don't have a carry permit, then you can't carry a gun in your car, period. Unless you're on the way to the range or the dealer or between residence or the way to the business. But other than that, if somebody's banging on your car, the question you have to answer is your life in immediate danger? Because you cannot use deadly force to defend property. So if you look out your window and somebody's breaking your glass on your car to steal your radio or rummage through the contents, can you shoot them? Of course not, because you're defending property. Your life's not in danger. You're looking out the window. You're not at risk. Now, if you go out there and want to stop him, because reasonable non-deadly force is available to stop someone from committing theft of your property, and it escalates from there into a situation where you are in imminent peril of severe bodily harm, like he pulls a knife on you, and then it's a different story. But you can see how this blends into questions of fact for the jury. And again, it's always a jury question for the trier of fact. It's not where you want to be. You have insurance for your car? Call your insurance agent. Call 911, say somebody's breaking into my car. If you walk out there armed, it's not going to end well. So these kind of judgment calls you have to think of ahead of time because you're not going to think of them at the time. So if somebody's banging on your car, well, depends on what they're banging on it with. If they're banging it with a crowbar and smashing in your windows, well, yeah, you're probably into severe harm range there because that crowbar or a bat is a deadly weapon. And they're about to beat you senseless with it. So the test is applied to that situation. Yes, you may. Might be easier to put it in reverse and back out of there. And a whole lot cheaper if you don't have to buy lawyers for that. So again, waves a gun at me. If the guy's waving a gun at you, that's first degree assault. You are in imminent danger of your harm. He's got a deadly weapon and he's pointing at you. The question is, can you engage that person who's waving a gun at you before he shoots you? Maybe. Doubtful. Got to be thinking about that too. It might be easier just to give up your wallet and walk away. It might be safer. A hard call to make. And again, how imminent that danger is, you could have a situation where there's 5 of them and 1 of you, and you're 70 years old and got severe arthritis. And you couldn't outrun anything, much less to try to fight off 5 young men who could beat you senseless. That's a pertinent fact for the trier of fact, whether or not you had a way to escape, and 2, where you were in imminent danger of severe bodily harm, especially if they were threatening to beat your head in. So again, different facts matter. And jury question. And he wants to know, can I point it? Well, you can't point your weapon unless you can shoot your weapon. You can't pull it just to scare people off, unless it would have been permitted to shoot them because your life was in imminent danger at the time. So the idea that you can use it to deter, most people who pull weapons, or the bad guy will look at the weapon and say, oh, I don't want anything to do with this, and run away. And what do? You let him run. Because at that point, the threat is gone. And you are no longer in imminent peril of severe bodily injury. So you have to think of this ahead of time. This is the kind of stuff we teach in these courses, how to do this ahead of time so that you don't make the wrong decision at the wrong time. And Lord help you if you actually do have to shoot someone and there's a dead body in front of you and you have to figure out what to do with it. And if that ever happens in your home or elsewhere, my best advice is say nothing to the police. hopefully the 911 call has been made. They're there. You better not have a gun in your hand when they arrive, because that could end badly. And if you're really sure you can pull this off, you can say, this man or person physically attacked me with that weapon that's on the ground over there. These are witnesses around me. And officer, I would love to cooperate with you further, but I really want to talk to my lawyer before I do, so I'm going to assert my Fifth and Sixth Amendment rights until that happens. Fifth Amendment right is the right to remain silent. The Sixth Amendment right is the right to counsel. The invocation of those two rights expressly, and they have to be express, under a case called Salinas versus Texas, U.S. Supreme Court case, will mean that the questioning must stop, and anything that you say after that point is inadmissible against you. You will not be able to talk your way out of that situation. Well, at that point, you need a mouthpiece. You need a lawyer. I can't stress that enough. And that applies to lawyers, too. I mean, I will take my own advice if I were in that situation, because I know I'm not going to be able to talk myself out, and I'm going to be so completely traumatized by the whole situation that I don't know what's going to come out of my mouth. Most police unions have agreements with the police departments that there's a cooling off period before they're allowed to interrogate an officer about a police shooting. And because everyone understands that it's a traumatic situation and they need time to collect their thoughts and retain counsel. So I can't stress that enough. So one person asked me, can you lie to the police? And it depends. You know, is it always a bad idea, but is it legally prohibited? Well, in Maryland, as opposed to federal law, in federal law, if you lie to a federal officer, it is a crime if the lie was material to the investigation and was knowingly done. That's 18 United States Code 1001. But a state officer, you can't lie when you bring a charge or file a complaint. But otherwise, the state doesn't ban you from lying to an officer. So when he says, did you do it? And I says, no, you did. That's not a lie. That's actually a crime in Maryland. So you have to draw that line. I'm not suggesting anyone should lie to officers. It's better not to say anything to an officer. But that's because that sort of misleading statement might be used against you at the time, because anything you say at the scene can be used against you. But the lie itself is not a crime. So that's a distinction that most people don't understand as well. So remember, anything you say at any time to a police officer can be used against you, and anything that you say that helps you can't be used at all. That doesn't help you at all. So nothing you say will ever help you at the time. It simply won't be available. And that's something that people don't understand as well. So don't try to talk your way out of it. Police officers, a lot of them are very skilled interrogators, and they'll get you to talk. Now, if you voluntarily resume the conversation, then you are actually reinitiating the conversation, and you've just waived all your rights. If you allow a search, if you consent to a search of your vehicle or your home, you have waived your Fourth Amendment rights. Why would anybody ever waive their Fourth Amendment right? Tell them to get a warrant. This requirement for a warrant protects the innocent. The Baltimore Police Department is absolutely an illustration that not all police officers are honest. They've prosecuted too many officers in Baltimore. So why in the world would you ever want to take the chance of talking to a police officer? So I get a question here. If someone was breaking into your house, is there any problem with firing your gun into the ground to frighten the person away? Why in the world would you ever do that? If you're firing the gun and you're not in imminent risk of your harm, that bullet could ricochet and hurt somebody. you're a crime. Firing a gun is itself something that is first-degree assault. And again, unless you can meet all the elements for the requirement of self-defense, imminent risk of severe bodily injury, then why would you ever fire into the ground? It's worse than firing to wound, because you lose the defense entirely, because if you had time to fire into the ground, then the risk really wasn't imminent. Remember that the knife is upraised, they're coming at you running at you, that's imminence. So if you can fire into the ground, they're still going to be on you. And if there really were an imminent danger, you've just lost your life to someone that you could have stopped otherwise. So under no circumstances should anyone ever fire the gun into the ground. If they're too far away to pose an imminent risk, then don't pull it at all. So you can defend your home, you can defend your life, but it's a difficult legal burden to actually get to that point and convince a trier of fact. Now, it does happen. In Montgomery County a few years ago, there was an invitee, a very powerful former Marine who became drunk and belligerent and very threatening. And the homeowner who had actually invited this person there became very frightened. And when the person charged him, and because he was powerful enough to break him in half, he shot and killed him. And he was able to go to the grand jury. This is not a legal strategy I would normally recommend, and convince a grand jury not to return a bill of indictment on ground of self-defense. Extraordinary, but it does happen. And the defense is there. But it's very difficult to meet in normal situations. That's why criminals often claim self-defense and very seldom are successful in it. Because all the prosecutor has to show beyond a reasonable doubt is one of those elements it doesn't obtain. And then this defense is gone. So it's very difficult for that reason. So let me see if I have any more questions here. So folks wonder about what they can carry. And I refer them to the criminal laws section 4-101 about carrying knives. And it has a broad prohibition on carrying concealed weapons other than guns, a knife or like. You may not carry a concealed knife unless it's a penknife. People say, what's a penknife? Well, a penknife is this ordinary folding knife, like a Swiss Army knife or a Boy Scout knife. Now, if it's a switchblade, and it's an ill-defined term, but the courts have construed that to mean spring-assisted, then that's a ban. You may not carry a switchblade. Lots of people carry switchblades, not knowing that would send them to jail for years. They can't carry open if there's an intent to harm anyone or use it to threaten anyone. So that's and that includes mace or tear gas or the like. And it's not clear whether you can carry a mace concealed, since that statute is so poorly written that no one is sure whether that is covered by the concealed carry provisions or not. So again, there's lots of traps for the unwary in Maryland. Now, you can carry a mace openly as long as you don't intend to hurt anybody and use it for self-defense. And since it's not a lethal weapon, it is something that's more available to you and probably gets you in less legal trouble than simply using a firearm, even if you have a right to carry a firearm. So there's lots of people who carry firearms have as their primary weapon a mace. And if that fails, then they resort to maybe a taser, which officers carry, or they can. And tasers are legal in Maryland now because of the Supreme Court ruling called Tantanello versus Massachusetts, and that is a secondary weapon. Again, non-lethal, and only in the last resort to resort to the lethal weapon. And resort to any lethal weapon should always be last resort. So you can see that my time here is expiring. I think I've covered most, if not all, of the questions. And If not, I'm going to ask everyone to help me this coming legislative session by showing up, finding about these legislation that will harm your rights of self-defense and harm your right to buy and carry a firearm, and go on our Maryland Show Issue website. All that information is going to be set out there as the legislation is filed. We put it up. You don't even have to be a member to access it. And contact me directly. You can send an email to info@marylandshowissue.org, and that email comes to me. Or you can send me an email directly at mpennak@marylandshowissue.org, and I will answer it. And I am not the least bit shy about answering general questions, but get us into very specific legal advice. We're reluctant to do that because at that point you really need your own lawyer. And even though I'm a member of the Maryland Bar, it's going to be impossible for me to do what I do as president and still respond to very specific legal advice situations. So we don't normally represent individuals, but we can give them guidance as to how to proceed. And we do that for members, for example, who seek carry permits. And it's easy to join. Just click on join and become a member. I will tell you litigation, and we're embroiled in lots of it, is very expensive. In the HQL litigation, we have two experts, renowned experts. Uh, their joint fees were $60,000 for the reports that they wrote and the time they put in. That's just their expert reports. The cost of transcripts is high. The cost of filing fees, it costs $400 just to file a lawsuit in federal district court. So none of this is cheap, even though I give my time away and every member of Maryland Show Issue is a volunteer. None of us are making any money at this. And we're representing everyone's gun rights in the legislature and in court. So we need everyone's help, because without your help, we're going to fail. And so show up on hearing days in Annapolis, get to know your legislators, let them know how you feel about something, and don't be shy. And if you have questions, please send me an email, and we'll do our best to get back to you. So I can see that we're about out of time, and so I'm going to bid you adieu, and I want to thank everyone for coming tonight and watching. It's been a great pleasure and an honor to be here. So good night.